Well, the buzz of conversation, and sorry to throw that, but I'd like to effort to this.
Thank you, Professor. Noi le fine che mi ha koutou, e ngā iwi, e ngā reo, e ngā mana teitei hui o te motu. Ni ki te koutou, e ngā koutou, te kia ora mai. Just to say, wherever you are from, on behalf of the Twitter, welcome here tonight. It's that's the duty that I have for us. So, e tō mātou mātou I te rana. E nei mātou ki ino atu nei kia koe ki nei pō. Tore ki o mai o te mare ki te mātou, me ki ino ki nei pō, ki nei te inoi. I roto I tō ingoa. Ai nei, atu tōne nei. Amen. Kia ora. Is that a good check?
I'm Lee Godden. I'm the Dean of the Faculty of Law here. It's my great pleasure to welcome you here today. And I have the great pleasure of doing introductions to this wonderful collaboration that is part of the broader work from the Justice and Relations Centre. So I'd like to introduce our two speakers. And we'll get to another discipline before we talk to them, because this is one of the wonders of this, that this is an interdisciplinary collaboration, and very certain in that way. So Dr. Nicola Kyler is a senior lecturer in forensic psychology at the Centre for Forensic Behavioural Science, Queensland University of Technology, but she is also a research fellow here at Victoria University of Wellington. Nicola's interests, her research interests and areas of expertise include etymology and prevention of arson, deliberate fire setting. This is quite an interesting including also research into sexual violence prevention and mental health needs of just involved people and staff, and all that obviously tonight in terms of the presentation. And secondly, Professor Yvette Tinsley is the academic co-director of the Te Herenga Waka Centre for Justice Innovation. As a criminal justice academic, Professor Tinsley has a special interest in legal policy reform, particularly improving the experience of participants in the criminal process. Her work has resulted in extensive legal and policy change, particularly in areas of jury trial, practice, and sexual violence pre-trial reforms. So who better to speak to us tonight on the topic, which is a very under-researched area, as I've found out from the post we've written today. Scar tissue. That I wish you saw, understanding and addressing the wellbeing impacts of working in the criminal law. Thank you. I have over to you.
So just before we kick off, it's probably something that you're all aware of, but just a quick content warning that some of the things that we will be talking about and some of the quotes that we'll be using tonight might be distressing for some people. So just take care as we go through. On a lighter note, we didn't plan on me saying anything about this, but I'm very proud of the title, Scar Tissue That I Wish You Saw. And I was thinking that I might give an extra drink to anybody who recognised that song lyric. For those who've been in any classes of mine, you know that I'm quite obsessed by song lyrics. People did talk to us a lot about building scar tissue, and that made me think about this particular Red Hot Chili Peppers song. So what we've got is a little bit different, looking forward to the Q&A. Because this is quite sensitive material, and for some people it might be quite difficult to pop your hand up at the end. We do encourage you to pop your hand up at the end. But we've also put together a Go Soapbox discussion. So you've got sitting around you, there are some bits of paper with the QR code on, or if you can't do the QR code, to a link if you've got a device with you that you can pop into your search browser. or you can just take a photo of the slide right here from the screen. Take a photo. Scan, showing my age. So what we will do is we've got those coming up and we'll be able to see what kinds of comments and questions people have got, and we can bring some of those up at the end so that everyone virtually and also in the room, if you don't feel comfortable putting your hand up in the Q&A, we will be able to deal with some of those queries and comments as we go. Okay. So first of all, you'd have seen that in the foyer that we've had a wonderful research team of students helping us with this. And I just don't think we could have done the work without them. We did it on the smell of an oily rag, but thank you very much to the Faculties of Science and Law for giving us the smell on the oily rag. Because it was really wonderful to have the strategic research funding that both of those faculties gave us. So whilst Nicola and I are presenting tonight, we have to acknowledge the wonderful research assistants and postgraduate students who have helped us to achieve the research and the outcomes and to do all the data analysis, and a couple of them are still for love helping us do some of the work on this. That's a list of all of our people there, some of whom you might have met out in the foyer. So what is it that we were trying to do? Well, as Lee said, it's quite an under-researched area. So there's certainly a lot of research about other helping professions. So people like nurses, psychologists, social workers, and that's identified that emotion work or working with potentially traumatic material can really lead to a risk of developing burnout and vicarious trauma. But until now, there's been almost no New Zealand work and very little international work around the legal profession. So there's been a little bit of work on judges and a little bit of work on lawyers, but it's been relatively narrow. So really we set out kind of around COVID time and had some grand ambitions across different jurisdictions. But because of those restrictions, we've ended up doing something quite New Zealand specific. And in a way, I'm really glad that we were forced into that position because it's given us a real insight into our legal culture. And we can see some of the similarities with other cultures and some of the other work that's starting to come through from elsewhere. But it also gives us a real picture of our home. So what is it we wanted to do? Well, we wanted to understand what's going on when people work in the criminal courts with potentially traumatic material, and also when they work in the wider justice system, when they're legal professionals of any sort who are working with emotion. And we're not only focused on the negative impacts, although as you will see tonight, unfortunately, a lot of those did come through from our participants, but also what are the positive impacts or the things that we can leverage for motivation to continue in the profession and to help people to stay well. We also had a look at management strategies. What is it that people are doing to stay well or to try and get well? What are the kinds of factors that influence whether they seek help or not? What is the role or the potential of legal and professional education? And that second bullet point is one that we've done a little bit of starter work on and asked some questions of participants about, but it's certainly one that we want to delve into some more. What can we do to start to build that resilience and well-being right from the time people enter law school through to entry into the profession, rather than trying to address some of those issues once people have already become unwell? And we also wanted to look at, we are researchers, what kinds of reforms can we think of? And that's always a fun part of any project, but also what spoke to us from the participants is how much some of those changes are needed. So we will end up the formal part before we go into Q&A today with some ideas, some tentative ideas we've got for ideas that might make things better from the things that we've heard. And that is not to discount what's already been going on in the profession, but it's also to say that actually our participants did not find that the help that's currently available was sufficient for them mostly. So when we get to that point where we're kind of doing our excited, we've had these thoughts, we would really welcome your feedback on some of those ideas. Now, this methodology that we used, and I'm fully a quali researcher. I do like numbers, but I don't do quant. Nicola can do both because she's special. But this was a qualitative piece of work. We took Crown prosecutors and we included some Crown Counsel in that, police prosecutors. We also then looked at defence lawyers and we tried to have quite a broad group of those. So we worked with some people at PDS, were some of our participants, some sole practitioners, some people who were in firms of various sizes. We took people who had a range of experience from different size firms, people who were from rural and urban locations from both North and South Island. So we tried to get a range of experience so that we could start to build a picture of what was going on across whatever, if you've been 1 year or if you've been 20 years, like what's the impact for you? And we were quite overwhelmed when we put the call out for participants. We didn't have the funding to do as many people as came forward, but we did interview 90 people across the students and ourselves in this wider project across those 3 groups. So that was 32 Defence Counsel, 15 police prosecutors and 43 Crown prosecutors. Most of our interviews were about an hour to an hour and a half long, so they were quite in-depth. And the age range, as you can see there, 25 to 67 years old. We particularly wanted to get some practitioners who were Māori and Pasifika, because we would really like to have some students from those groups who can come along and do a little bit more depth of work in with those groups, because there are some things that affect people from those cultural groups a bit more. And we managed to get 15 Māori participants, 5 Pasifika, 18 New Zealand European, and some people who were in other groups or who did not identify. A huge experience range, some people who were new and some people who had got up to 37 years experience. So we're going to talk for the rest of the time about some of our key findings with Crown prosecutors and defence lawyers. And I'm sorry to anyone who's come along really wanting to hear about police, but we've still got a little bit of analysis to go around how the police prosecutors, who have got some quite different experiences as well as some commonalities, how that kind of works together with the other 2 groups. So where we're talking is mainly tonight around Crown prosecutors and defence lawyers. And we've got Alex in the room somewhere. There she is. So Alex is doing some work on the police prosecutors and will be reporting back once she's finished her work, and your thesis will be available once you've finished up next year. So look forward to that. So one of the first things that we talked to participants about was, well, why is it that you're criminal lawyers? Like, what draws you to it? What keeps you going? Many people spoke about really altruistic reasons for being involved in their job. Somebody said you can go home feeling like you've made a big difference in someone's day, even if that's only been a small gesture. So real impacts that they felt that they were having for individuals, whether that be complainants, defendants, their whānau, they were really feeling like they were making a difference, and that motivated them. And one said it's meaningful because you're contributing to someone's life and you can see in a tangible way the impact that has for them. Many of the people we spoke to had quite a lot of pride in their profession. Prosecutors spoke a little bit more about status and reward, but also about helping complainants. And Defence Counsel focused a lot on the ideals of equality of arms, offering a voice for people who would not otherwise have a voice. All of the people that we spoke to tended to speak of helping to address a community need. And as one person said, we play a really important role in the community. I find it really rewarding. It's a great job and you feel like you're actually contributing. So that meaningful community role is one of the main motivators for the job. But it was quite clear that there are impacts, some of which are not necessarily located just in the criminal courts, but where criminal work may exacerbate some of it. And one of those is the feeling of a very pressured work life with lots of responsibility. So long hours that are irregular, often very large workloads that are quite fast paced. You don't get time between cases. You might have lots of cases going on all at once. And somebody saying, you can't be worried about yourself when you've got all these other people to worry about. They didn't sign up to be in the system, so you've got to do the best job for them and cope with it later. So this sense of responsibility to defendants and complainants and putting their own well-being to one side often in order to be able to help out the people who were, whether they be witnesses, complainants, defendants, whoever they were working with. There was a real sense of a feeling of pressure because this was people's lives and sometimes people's liberty that was at stake. And so that pressure was really felt. And someone was talking about how as a prosecutor, you really feel that you have to be perfect every time and that the court expects you to be perfect every time. And then you'd speak to defence counsel who would say, we've got to bring our A game every time. There's no way there's no room to bring your B game. You've got to bring your A game because otherwise this client that you've got might end up with a conviction because you didn't bring your A game. And so the stakes are really high for us. I know that prosecutors really felt that they were supposed to be the officers of the court and therefore their behaviours were watched much more. By contrast, defence counsel said, hey, prosecutors, they're like the good kids at the front of class. We're the naughty kids at the back who are kind of creating all the trouble. So for both groups, there were issues around this idea, this pressure that they had to be perfect in the role that they were performing, and a real awareness of the high stakes. Now, for defence lawyers in particular, there was a real feeling of the consequences of doing what the literature calls dirty work. So when you're doing something that might not be seen by society to be very palatable, where there's stuff happening that that you come across that actually you just can't talk about at the dinner table. So for both prosecutors and defence counsel, they spoke about that, and Nicola will touch some more on this later. But for defence in particular, this came through in terms of feeling hostility from the public, sometimes from their family and friends, so feeling villainised sometimes by people in their social circle. And someone said, you should see some of the emails I get. You obviously don't have any daughters. I've got 3 daughters. You deserve to be raped yourself, stuff like this. And what they reported to us was a lot more negative reports about the way other lawyers treated them as compared to prosecutors. So more defence counsel complained about the way judges spoke to them, alleged allegations of bullying behaviour, the way that the profession as well as people outside saw them. So a real sense of that isolation of doing the so-called dirty work and feeling like they have to justify the role that they do. When, defence lawyers, they're, because of equality of arms, protecting people from the system, but they're having to justify that all the time. That sense of not being popular. For both prosecutors and defence, there were issues around emotion. So we found quite a lot going on in terms of how people dealt with the emotion of the courts and of other people and themselves, and what we expected from them in the profession. So very strongly what came through was about the industry belief that there's no place for emotion in the law. So although we all know that courts are emotionally charged places, actually that putting it aside, being objective, is prized above all. One prosecutor said, I don't think a prosecutor can be a robot. Our job is to relate to complainants and witnesses in a way that acknowledges the experience they've had, which is often tragic, and we need to relate to the jury as a person. So you can't show your emotion, but you can't be a robot. So there's a tightrope of walking through, showing empathy, doing the right things in terms of showing the jury that you're a person, that you're a human being, but at the same time, not showing emotions in the public arena of the court. People spoke about things like going and crying in the toilets and not doing that in public, for example. There was a sense that emotion meant that you lost your objectivity and therefore could not perform as well. And a pressure to conceal emotions from both their peers and seniors. And we had a lot of people relaying to us that they were fearful of being seen to be weak or as if they could not cope because of the impacts that might have on their career. And yet, at the same time, this tightrope of the importance of displaying empathy. And someone said to us, you manage emotion by not having any emotions at all. So by putting aside, putting in a box, compartmentalizing your own emotions. We have to present ourselves in an objective manner. We do not change our facial expression or tone of voice. So it's kind of hard being a human being. We can't get involved in their emotion. And what they mean by that is there are people in court all the time who are angry or who are sad or who are crying, and we can't get involved in that. We have to step back and we have to still be objective. But that emotion still has to go somewhere. People tried using a clinical approach. I'm going to focus on the legal aspect of the materials, and then I don't have to think about what's going on in terms of the emotion. I'm going to disengage from the emotion that I'm feeling. And a lot of people spoke to us about creating a lawyer persona that was separate from themselves as a person outside of their work, so that they would carry that lawyer persona and it would kind of protect them and allow them to put that emotion in the box. As well as all of that happening in individual cases, we saw people struggling with their emotional response to working with systemic inequity. So quite a lot of people reported distress at witnessing, and for some feeling that they were participating in the continued impacts of colonisation. And that particularly affected our Māori and Pacifica participants, but not exclusively so. There was also a sense that defendants within that system were treated badly, and some distress at that. A lot of people spoke about, particularly defence lawyers, unsurprisingly spoke about offering emotional support to clients, but feeling pulled a little bit into social work role and how difficult it was to not get pulled into that. And someone said, you'll do everything you can for your client up until the point you become a social worker type person. And someone actually just yesterday said to me in the context of family law, they advise people, don't get in the client's waka, because if you get in the client's waka, you'll both sink. You need to stay at the shore to be able to help that person to keep afloat. But that's a really difficult thing to do in the moment. And people felt a real sense of frustration across both of our groups, or in fact all of our groups. They were working in a broken system, that there were things that were going on in a systemic way that made their work harder. So what was the impact of all of that emotional labour of having to have display rules where you were kind of feeling one thing but exhibiting another? Well, it was a lot of exhaustion. Someone said it's not a physical job. Obviously, you're not digging ditches, but emotionally stuffed. And it can be a day where you're mostly just sitting in a chair and you come out and feel like I've run half a marathon. So when you're trying to manage your emotions and display something different to what you're feeling inside, it does make you exhausted, but it can also have other detrimental impacts on your well-being. That stress of long and irregular hours, complex work with few breaks, walking that tightrope of masking emotion and expressing empathy, and then dealing with other people's emotions, judges, participants, their whānau. Some described feeling really burnt out and not being prepared for that when they entered the profession. So not having sufficient tools to be able to keep themselves well and avoid that burnout. So that's what was happening in terms of that emotional labour. Now we add into that, and that's, some of those things are not going to be uncommon, whatever area of law you're working in. the long hours, the irregular hours, the burnout. But when you add into that the complexity of criminal law in terms of potentially traumatic material, we can start to see the picture getting a little bit worse. And I'm going to hand over to Nicola to talk to you about that.
Okay, so following on very nicely from where Yvette just kindly left off, all of the groups that we have worked with have spoken about this inevitability of being exposed to trauma and potentially traumatic material by the very nature of working in the criminal law. The sense of trauma is everywhere. They're exposed to it in every aspect of their working life. And this inevitability led to beliefs that it's part of the job, it's an occupational hazard, this passive acceptance that it's there, I can't avoid it, there's nothing that I can do about that. And so there's nothing you can do from it damaging you, you can't avoid it. You just need to harden up, toughen up, suck it up. It was also viewed by some of the profession more broadly, viewed this exposure to traumatic material and the impacts of it. It's just a process that you have to go through. It's just part of the process of working in the criminal law. And one participant noted, I don't see how you could engage in the type of material the way that we do and not experience a degree of trauma, not to experience a response to what that you're seeing. And certainly I know that I have trouble sleeping and find myself really preoccupied with things that I've read and heard about. And they would come back and they would occur at all sorts of times, even when you're just trying to engage in normal family or social life. It's this idea about the things that you've heard and seen coming back, and you're reliving those at different times when you're not at work. So how do the defence and prosecutors that we spoke to, how do they deal with working with traumatic material? Well, many of them talked about strategies that they'd developed themselves to help them continue to do their jobs and continue to manage and navigate the traumatic material that they're exposed to on a daily basis. Adopting strategies such as covering the faces of complainants or from people in photographs, avoiding content, putting it off until they absolutely have to engage with it, or compartmentalising reviewing of files to particular points where they felt they were at their best and most prepared and most mentally able to engage with it. Others also talked about, as Yvette briefly touched on, adopting an analytical approach, so really focusing on the facts and trying to separate themselves from the emotion and separate from the people and the harm that was involved, and really focusing it from a more of an evidence-based approach. And that was, as somebody's mentioned, was to avoid drowning in the emotions this elicited in them. And so one participant noted, reading whatever or looking at the photographs, you've got to be doing it for a specific type of purpose. So you kind of put the walls up and only think about what you have to. And that was then really talking about that kind of fact-based analytical approach that they'd adopted to the cases that they work in when working with traumatic material. Something that came out across, again, all of the groups that we worked with was the fact that working with cases involving sexual violence was the most traumatic material, the most traumatic cases that they had to work with. And they were noted as having a particularly unique edge due to the nature of the evidence and the nature of the harm caused in these particular cases. Both prosecution and defence reported that there were these added challenges, and working with sexual violence cases was kind of putting additional pressures and additional feelings of additional responsibility, and also exposure to more difficult material on top of those workplace pressures, on top of the emotional material that they're working with and the emotional labour that they were having to engage in. It was really describing this additive effect as something on top of everything else that they're working with. And the effects that working with sexually traumatic material really affected both groups in similar ways. The content was described as really difficult, emotionally draining, exhausting. The intensity and increased pressure and responsibility that was felt towards parties in those cases. Particularly prosecutors talked about the high stakes responsibility and they felt towards the complainants that they were working with, wanting to get the best outcome. There was a negative impact felt across the board of working with back-to-back sexual violence cases, not having a break between trials because of that emotional intensity, because of that high feeling of responsibility. And in addition to that, it wasn't just because it was the emotional, but the impacts that permeated other aspects of both prosecution and defence lives. Many talked to us about how they weren't able to be intimate with their partners when working sexual violence cases. They weren't able to necessarily engage at home in normal tasks such as cooking dinner or doing the cleaning because they were just so emotionally spent from working on this type of material. And as one participant noted, that they're exhausting emotionally, they drain you to the nth degree. I've been married twice, and my wives in both instances described how I would finish a sex trial, a difficult one, and then go home and lie in bed for 2 days. So really capturing the exhaustion of working on those, particularly back to back. However, participants also noted that, particularly prosecution, that it can be rewarding working on those cases, providing a voice to a person when they're experiencing one of the most difficult things of their lives and guiding them through a really difficult trial process and supporting them. So really sort of mixed feeling there. In terms of the impacts that working with traumatic material, many of our participants talked about how working in the criminal justice system and seeing the dark side of humanity and what some people refer to as what they call the real New Zealand, the things that other people don't necessarily get exposed to, meant that they ended up having a changed view of the world, that they saw the people in the world differently. They actually, their outlook on the world and the city that they lived in, things looked a little bit different. Some participants reported that, there's an extra layer on top of the city, that it was tainted, and that when they were out and about or they went to particular places, that they would, instead of experiencing a particular social activity, they would think, oh, that's where this particular thing happened or where this particular crime occurred. So it impacted that way. More broadly, people talked about experiencing increased suspicion towards others, reduced changes in trust, viewing particular groups and interacting with particular groups that they perhaps came across in the work that we're doing, interact with them in different ways, and that some groups have become, as I said, tainted by their work. And so we've got, one participant talked about my kids, my poor kids. So they will never have one-on-one music lessons with male teachers, ever. So that taints an entire group of people. I would never have a male babysitter, and that's just because of the generalisations from my work. So it's really impacting how they view particular groups and also the trust they have in them and the decisions, and those impacts widen out to their loved ones and friends and family. There's also a real sense about, because of what both defence and prosecution seen, that they could never be normal, as they put it again. The things that they'd read or heard were, we were told that they were recurring back at times. They were trying to engage in normal family or social life activities, recreational tasks like going past a particular park or something, as I mentioned, triggered memories of cases that they had worked on. And they had an increased awareness of crime and experienced paranoia, hypervigilance, things that they hadn't experienced prior to working in the criminal law. And some people took active approaches to adjust their worldview because they were aware that they were viewing things in a different way, in a more of a negative light, and was actively taking steps to try and shift that. So this quote, I think, quite nicely captures some of that hypervigilance and suspicion that people are experiencing, and that increased alertness to what might be going on around them. So I'm quite suspicious of people. I'm not very trusting. Little things happen and I catastrophize a bit. I'm a lot more wary of my personal safety if I go out at night and say I'm walking to my car by myself. I'm a lot more aware as to where I park my car, all the things about carrying keys in your hand. Even though I know myself, chances of being raped in the car park are pretty much nil. Doesn't mean that I don't think about those things. And this person was talking about that they were taking these steps and being more suspicious and hypervigilant based on the knowledge that they had gained from working in the criminal law. So, although the lawyers that we spoke to were talking about how they were impacted by the work that they were doing, what does this mean in terms of actually seeking support and being able to access help? Well, many participants reported really feeling separated from the rest of the world because of the nature of the job that defence and prosecution are doing. They experience barriers to speaking to people, particularly speaking to others outside of the profession. One part of that was down to the confidential nature of the work that they were doing, but also this feeling that other people just don't understand because they don't see what I see, they don't hear what I hear. They have a different world. But not, and again, it wasn't just that though, there was also a desire to protect friends and whānau from being exposed to the type of material. Defence lawyers also spoke about how actually, some people wouldn't have much sympathy for them if they said that they were upset by content that they saw or they felt sad or distressed by a particular case because, you're a defence lawyer, what do you expect you're going to find? And that really fed off that hostility that Yvette talked about that defence lawyers reported it being from the public. And this meant that for many people that this left their colleagues and immediate colleagues as being people who could understand, who worked in a similar profession, as being people that they could talk to. And so they just stopped talking and seeking support externally because of that. So you just have to talk to your colleagues about it and accept that your friends and family just can't help you with that stuff. However, as I'll go on to talk about in a moment, the relationship with colleagues was also felt to be conditional in terms of what you could speak to colleagues about, how much support you could speak to them, how much support that you could gain from other people that you viewed as being able to understand what you did. Okay. So participants talked a lot about physical and mental health impacts that were experienced as both as being exposed to traumatic material, but also as a result of some of the nature of the work that they did, the long hours, the high workloads. So some of these impacts are experienced by people working in other areas of the law as well, but also impacts that came particularly from the emotional labour and the exposure to traumatic material in the criminal law. High stress levels that have little respite were commonly reported, not having the chance to take a break, have a moment to catch your breath and recover before going into another case, experiencing burnout, disrupted sleep, experiencing depression, also experiencing physical health impacts such as palpitations and digestive issues as a result of that stress and burnout. A number of participants also reported PTSD type symptoms, so experiencing intrusive thoughts, recurring nightmares about the content that they saw and how that would impact different aspects of their life. So I talked very briefly about obviously colleagues being a potential area of support for people who work within the criminal law because they have that understanding of the work that they do more so than other people who are not working in that profession or working in the justice system more broadly. But there was a lot of discussion around how the workplace and professional cultural norms really prevented people from wanting to reach out to others within the profession. There was a general consensus that while peers can understand, there was some mistrust because participants viewed that they viewed this as really as conditional support because, we need to be practically perfect, need to be infallible. And if I show emotion, then I'll be showing weakness. And this might have impacts for career progression or particularly for defence. This might be work that doesn't come back round again, or people might see me as not competent or capable to be able to do my role. There was also this general sense that as lawyers, it's not in our DNA to ask for help, so don't ask for help. That's just not what we do. And there was this as the quote says, there was this real attitude: if you can't handle the heat, don't even be in the kitchen. You don't belong here. And to show weakness or vulnerability is pretty frowned upon. So if you can't handle it, you should be working in a different part of the law and a different profession. Participants also talked about a modelling of building scar tissue, and this was something that came up more so, not exclusively, but more so with more junior participants who were talking both in defence and prosecution. There was this view that more senior practitioners and partners were desensitised to what they had seen, that they were hardened, that they were immune to the exposure to potentially traumatic material. And there was this view that desensitisation was the golden standard. And so as one participant noted, I'm hopeful that in 10 more years, I'll be a little less affected like my bosses are. So people actively striving to stop feeling, stop hurting anymore and just be able to continue. There was also, in terms of not just the modelling of this view that people who have been working in the criminal law for a long time didn't feel were more hardened to this, but also the ways in which this was modelled amongst various different places and through more senior people. So one participant noted, well, we can't have emotional reactions. There's one girl, and I know what her views are, so I'm going to make her sit down and, well, not make her, but I suggest that we sit down and watch the rape complainant's evidential video together. If I can see the slightest hint of emotion, she'll be off the trial. I can't afford to have people like that work with me because it's at the expense of my client. Because what if a tear rolls down her face in court in front of the jury while the complainant's giving evidence? We don't have room for that. So modelling that we go through these processes because we shouldn't be feeling, we shouldn't be showing that emotion, we shouldn't be affected. We can carry it. Okay, so some of these obviously highlight some barriers to help seeking. And there were other barriers that came up as well. These were sort of the broad ones we talked about, but other barriers that cropped up included having to jump through hoops or ask others to get access to services. So because of that workplace culture and some of those professional cultural issues around not showing weakness, emotion being something that we want to keep out of the law, this meant that when firms or when practices had counselling services available or support available to staff, that having to go and ask somebody for a referral meant that people were less inclined or less willing to do that, because if I have to go and ask somebody for a referral, I'm going to have to tell them that I'm finding this difficult. I'm going to have to show emotion. I'm going to potentially have to show that I have some sort of weakness, and then the fear of potential repercussions and impacts from that. For defence, particularly small chambers and sole practitioners, financial costs of paying for adequate and appropriate support where people could actually access this and access it at a time and a place and of a level that they needed was a real barrier for them. In fact, a number of people told us that they put it off because actually time out of work means that they're not bringing in money, and actually they're having to then pay for that as well, and that has a reduction on the income as well. A number of people also talked about having developed unhealthy coping mechanisms, and this ranged from alcohol and drinking alcohol. One participant talked about how lawyers and alcohol are similar to vampires and blood. This is what we do as a coping mechanism, and that was quite common. But there were also other healthy coping mechanisms where people, as we talked about, pushing those emotions down, not talking about it, just trying to struggle on and get through. Pass on to you. Yeah.
So Nicola's just spoken about the fact that one of the barriers was to trying to get help if you have to jump through some hoops. But for the people who then access support, there was also a barrier in that there was a feeling that there wasn't a lot of appropriate support around. and a real sense that external support was geared a little bit more generally towards workplace wellbeing, rather than being able to access someone who knew a lot more about how to work with people who had worked with traumatic content, or knowing more about the criminal justice system or forensic work. And a couple of people spoke to us about that once. And I remember talking to the counsellor I went to see, and she was horrified that I worked with child sexual abuse cases. And I thought, actually, this isn't going to be helpful if you have no idea of the kind of cases I'm working with, and you're so horrified that I'm a young woman working in this area, because I'm coming to you because I am horrified. So I'm not really going to get much help if you spend the whole session just being really traumatized by the work that I do. And someone else said to us, a lot of psychologists, counsellors, I guess they're all used to horrible things, but I needed to talk to somebody that understood our job and what we did. So the same kind of thing that's stopping, one of the reasons why they don't talk to family and friends, some of our participants said we can't talk to psychologists and counsellors who don't understand what we do. I don't want to have to explain that to them. And that's why I think going forward, any professional supervision needs to come from somebody who really understands the justice system. And that is one of the things that we're puzzling through in terms of how can we actually make that relevant? What can we do to make sure that the access to support is an access that is more relevant to the people working within the profession? So I know that we've probably made you all feel quite despondent, and for any people who have not yet entered the profession, I don't want to completely put you off working in the criminal law. It is a great area of law to go into. So to that end, we have been puzzling through tentatively, but starting to think about what other work we need to do to test some of this out. Some ideas for encouraging help seeking and wellbeing, some of which are about individuals and the profession, and some of which are kind of wider wellbeing support that we want the government to get involved in helping with as well. So these are things that we would quite like to have some of your feedback on as well. So one of the things, as we've just been talking about, is that we'd like to see a review of the industry provided wellbeing supports that are already out there, because we want to be looking at supports that are tailored, accessible, funded and confidential. And we know that some individual firms have made some great leaps ahead in that, and they are to be congratulated in that. But we know from talking to participants that there are still some significant holes there. A review of working practices. So what a lot of people told us was, well, I get my well-being from being able to do things at work or have my work organised in ways that helps me to stay well. Things like, I don't want to be working 3 back-to-back sex cases. That actually my employer will give me a bit of a break between cases like that so that I can look after myself, so that I can do a good job on the next one. So thinking about, and we know that there's funding constraints everywhere, but thinking about ways within those constraints, we can set in place some working practices in individual firms and in individual organisations. One of the really important things that came through to us, and again, it's something that I know some firms have already made huge changes on, around senior staff modelling help seeking and modelling positive coping mechanisms. And Nicola talked before about the modelling of the scar tissue of hardening up, something that came through so strongly from all of our younger participants in particular, but we could see the impacts of that with some of the more experienced practitioners too. The people who modelled that it's okay to feel a bit crap about the fact that this has happened, or that you've had to see that stuff, or that you've had to deal with that case. It's okay to actually show that humanity and to say, I'm struggling too as a senior person, it still affects me. That made a huge amount of difference. So there's a lot there in thinking about having that peer support, but unless you have that kind of top-down modelling as well of positive coping mechanisms, then it can only go so far that you've got peers who you can talk to. Because that's when we do get into what we were seeing, some people reporting, I go into the toilets at work and I might have my friend who will understand, but I won't tell anybody else. There's no way I'd ever tell anybody else because they just won't understand. Things like short stress breaks after individual cases, even if it's just allowing people to go for a walk, little things like that can also be positive coping mechanisms, as well as things like exercise, hobbies, other forms of self-care. And one of the other things we're really quite keen on is ongoing training across all levels of staff. As I just said, normalising the emotional impacts of the role, it is going to affect you because at some level, even if you push it down, because you are dealing with impactful material. Be aware of the positive rewards as well as the negative impacts. People spoke to us about some of the great things they get out of their work. And I think us kind of elevating that a little bit more than we do in the profession would also be a good thing. And a real kind of profession-wide promotion. Again, I know there's funding constraints and system constraints to this, but healthy working hours, work-life balance, scheduling some self-care, the people who do that are able to have their well-being coming out looking quite a bit better. And so to actually support people to be able to put that in place is something that's so important. So that's the stuff that we can kind of do at the individual employer and employee level. But there's some potential wider wellbeing supports. And this is where people know me. I like to poke the stick a little bit and see what might fall out of the government's coffers. We would like to see, going back to those quotes about who is it that we're going to get access to talk to, a consideration of having some professional supervision. Lawyers are the only caring profession that don't have access to that I can think of right here at this moment. To try and get that greater access to counsellors and psychologists than we currently have. But what we need to do is ensure that those psychologists have appropriate justice system training. So this is not just about the legal profession. This is also a call to the psychologists and people who are training psychologists. Let's improve psychologists' knowledge and understanding so that they can actually do that work appropriately. We think there's a whole bunch of work to do on legal education. And by that, I don't just mean law school, I mean professionals, and I mean ongoing education. Promoting self-care, awareness raising about what the impacts of the work might be, allowing people right at the start of their careers to put in place those healthy habits that are going to help insulate them from the inevitable traumatic work that they're going to do. A profession-wide access to basic support devolved from firms to ensure sole practitioners and small firms are covered. And one of the ways we think we might be able to do that is to explore aspects of wider government-funded health supports. So, for example, if you're someone who's been working on a serious criminal case, or if you're somebody who's been involved in a prolonged family case, actually legal aid should be stepping up to provide some aspect of wellbeing support that those lawyers can then access. And that might be a psychologist, or it might be that you want traditional massage, or it might be that you want whatever it is that makes you feel okay. But part of the puzzle for us is PDS, Crown Solicitor Network. We can kind of shove funding through that, but that leaves defence lawyers who are sole practitioners or in small firms out at sea. We need to devolve that so that it's not just those individual firms that are responsible. Otherwise, we are leaving some people in a situation where they're not going to be able to get that wellbeing support. And we would also like to see a regular review of the efficacy of any profession or government-funded ongoing wellbeing supports. Let's do more of that testing of the wellbeing of the profession. And it is really important, I would finish with this before we head to questions and comments, but the importance of this has been underlined to us just last week in Victoria in Australia, where we saw that someone who was working in-house at the coroner's court, that their employer has had to plead guilty to a number of offences around employment, because they had basically allowed a toxic work environment to continue. Much of that was about the stuff we've talked about tonight. Long and irregular hours, stress, burnout, an exposure to vicarious trauma. And unfortunately, one of their solicitors took her own life. So there's a duty of care, but also, I guess, what I'm saying is when we're going out and going, government, you need to give some money. There is a risk for employers if we don't see that duty of care being fulfilled. So I don't know, I don't have more to say than that, Nicola, do you? I think it would be really great for us to, and we can have a little bit of a breather so that you can de-stress, but any comments that you want to send through on the Go Soapbox, and we'll have a little breather and then come back to any questions or comments for the Q&A. Luciella's got those working around for us.
Kia ora, I'm John Walker. I'm one of the co-directors of the Centre for Justice Innovation. I have the really easy task of thanking a number of people who have supported this evening. But can I just say one thing? I've been in the legal profession and a judge for, I had to add it up because I always think it's not as long as it is, 46 years. And a lot of that time's in the criminal law, exposed to all the sorts of things that we've been talking about tonight. I still feel fresh and enthusiastic, but I also feel really lucky that I'm able to say that because this conversation, this thinking about support and help has been a long time coming, and it's a new thing, but just as well, I would say, because not everybody can be lucky, at least lucky so far. And so I want to commend all of the work that has been done to bring this out into the open, and how appropriate in Mental Health Awareness Week. I don't know whether we knew that when we set this date. And I don't think that it is something confined to what we might describe as caring professions. We look at them because they've had this for a long time and we're coming to it late. But unless all of us, practitioners, judges, are well in what we do, then justice itself is at risk. So there's a good reason, I think, why we need to be taking this seriously. So thank you to the Faculty of Law, and Lee, thank you for supporting us as usual in our endeavours. Thank you to the Michael and Suzanne Boren Foundation for their ongoing support for the centre. To Anna Burnett, our person who has was from the centre, who has put so much work into making this evening such a success. And thank you to all of you, both here in person and online, for your animated contribution and involvement and engagement. And I think, you know, the questions that have been asked and the comments and contributions made probably demonstrate in themselves how important this topic is to all of us. And I know we've been talking about defence lawyers, prosecutors, police prosecutors, but judges are in this as well. All right, thank you. Thank you very much. Hold on to thank Nicola and Yvette for the presentation tonight. It almost went without saying. But thank you very much. Thank you.
Just getting the nod to do our final karakia for the night and reinforcing this kōrero to look after not only each other but look after ourselves as well. Ko reira tēnei te mihi atu ki a kōrua, ngā kai kōrero, kei te mihi, kia koutou katoa, tēnā koutou kia ora, mino i tātou. E tō mātou i te rangi, tēnei no mātou tēnā tēnei kia koi, i tēnei pō. Me ki te riha pai te mai ki rongi a mātou i tēnei mahi o te roia, Me ki I tēnei mahi o te kōti, tēnei te inoi, I roto I tō ingoa, aia nei, a ki tonu nei, amene. Just to say, look after you all in the mahi that you do, whether you're a lawyer or other kai mahi around that activity in the court. Morena, tēnā koutou ka ti, kia ora mai. Thank you all very much.